welcome to today's Power Hour Legal Hot Topics 2026, the year ahead in HR compliance. My name is Shelby Bohr, and I am the events coordinator with the Chamber. We are so happy to have you here with us today. A couple of reminders, we have a Power Hour session scheduled every month for 2026. They are at 12 p.m. on the first Tuesday of the month via Zoom. We are also recording each session and adding them to the Member Resource Center. So if you miss a Power Hour, you can go back and watch it later by logging into your Member Information Center. Before we get started, please put your name and business or organization in the chat so that we know who is here with us today. We will be monitoring the chat for questions, and we will hold a Q&A at the end. Today's presenters are Mitch Guimond, Kyle Heslin, and Emily Demon. Mitch Guimond is a human resources coordinator at IRONWOOD with over 8 years of private sector HR experience. He specializes in employee relations, investigations, compliance, ADA, FMLA, and training, and has worked with both union and non-union environments within the security and technology industries. Mitch holds a Bachelor of Science in Psychology from Washington State University and is an SHRM CP certified and licensed private investigator in Texas. Kyle Heslin, SHRM CP, is an experienced human resources consultant specializing in employee relations, workplace investigations, recruitment talent management, and compliance. She holds SHRM CP certification, SRHM's workplace investigations, specialty credentials, and additional certifications in mental health advocacy and DEI. Kyle serves as the 2024-2025 Communications Chair for the Lewis and Clark SHRM Board of Directors and lives in St. Louis, Missouri. Emily Demon is a human resources coordinator with a background in hospitality and experience management teams up to 120 employees. She brings strong expertise in recruitment, communication, and employee support, aligning her work with IRONWOOD's core values. Emily is SHRM CP certified, holds SHRM specialty credentials in talent acquisition and workplace investigations, and is a licensed private investigator based in St. Louis, Missouri. Mitch, Kyle, and Emily, the floor is all yours.
Perfect. Thank you, Becca. All right, well, we can jump right into it. So we're going to be covering 2026 regulatory updates, going over what's changing, what's important, and how to stay ahead of some of the regulatory updates that are going on. Kyle, next slide. All right, just a quick disclaimer. We are recording this. I know Becca mentioned it before, but we're just letting you know that it is being recorded. If you have any issues with it being recorded or being involved in it while it's being recorded, just reach out to the facilitators. Next slide. Another disclaimer. So with any sort of topic where you're discussing regulatory updates, it's a snapshot of a moment in time. Laws can change as we've seen over the last couple of years, and as we'll be covering today. So while we're providing the best information we can currently, just be mindful that things can change. And if you are dealing with a situation, it's always a good idea to double check the regulations or reach out to legal counsel if needed. Next slide. All right. So as far as 2026 goes, there are some big changes that are coming down the pipeline. It's really been kind of a transforming regulatory landscape. The big one, minimum wage went up to 15 per hour as of January 1st. And there have also been some pretty big federal court decisions that have taken place, which we'll be covering here shortly. Additionally, there's things like the paid sick leave that was repealed, shifts in independent contractor tracking, as well as exemption status. There were some changes there. There's also some big things like the Secure 2.0 that we'll be covering today. So essentially, there have been a lot of changes, and we're going to do our best to try and cover as much of it as we can over the next hour. Next slide. So like I mentioned before, minimum wage is going up to 15. So while there was a law that kind of had step increases, this will be the last scheduled increase. That doesn't mean that it's not going to be increasing down the road. It just means that As of right now, this is the last one that's currently scheduled, but it is going up to 15 an hour. So for tipped employees, they do need to receive a cash wage of at least 750, so 50% of minimum wage. Um, and then if their tips don't bring their total compensation up to 15 an hour for that pay period, you do need to offset that shortfall. So what that means is if you do have tipped employees, you're going to need to make sure that you are tracking on their tips and then making sure that in the event that they don't quite hit that 15 mark, that you compensate them accordingly. However, there are some exceptions. So for small businesses that make under 500,000 in annual gross income, you do need to only pay the federal minimum wage of 725. So essentially 15 for most employees, 725 if you're under that 500K mark, and then for your tipped employees, you can pay them 750 an hour, but you do need to make sure that with their tips, their income reaches 15 an hour for a given pay period. And then the other big one that was kind of chaotic when it happened was the Missouri's paid sick leave. So that took effect uh, on May 1st of last year. However, it was then revealed or repealed on August 28th of the same year. So a lot of companies they shifted to having paid leave to comply with the state law, and then it went away. So as of right now, there is no obligation for sick leave. There's no federal mandates or anything like that. However, there is a proposal on the ballot set to be voted on in November 2026 to restore paid leave. So it's something that you want to be tracking on the back of your mind because it could potentially take effect in 2027. Next slide. Moving over to the federal side. So there have been some pretty big shifts, particularly as it pertains to exempt employees and independent contractors. For exempt employees, the biggest one was the salary threshold that was increased back in 2024 and 2025. That's been repealed. So what that means is we're back down to the previous salary threshold of 35,568 or $684 a week. So in order for an employee to be exempt from overtime, they do need to meet both that salary threshold, so that 35,568, as well as fall into one of the qualifying categories for exemption. So that could be executive, professional, administrative. Essentially, what that means is there's two tests that need to be passed, the salary threshold and then the duties test. Job title alone does not satisfy that. It needs to look at the actual work being performed. So just because you call somebody a manager doesn't mean they automatically qualify for that executive exemption. In order to do that, they do need to have at least two full-time employees or have hiring and firing authority. And then over on the independent contractor side, so it's been kind of an interesting shift. We've gone back to the previous economics realities test. So with that shift, it's more focused on 7 factors, focusing largely on kind of the economic control of the work being performed. So the main categories are the extent to which services rendered are an integral part of the principal's business, the permanency of the relationship, the amount of the alleged contractor's investment in facilities and equipment, the nature and degree of control by the principal or the business, the nature or the alleged contractor's opportunities for profit and loss, the amount of initiative, judgment, and foresight in open market competition, and then the degree of independent business organization and operation. So if you have your independent contractors, it's always a good idea to take a look at the actual criteria that's in place if you are looking at either having independent contractors or you already have them, just to make sure that you're satisfying that shift in the test. That said, with the 2024 rule, that is still in place for some private litigation. Essentially, what this shift means is the DOL is not going to be looking at it from an enforcement standard. So it is kind of an interesting balancing act. And then some states do have stricter tests. So if you're looking at hiring independent contractors outside of Missouri, you'll want to make sure that you're complying with those tests for the state where they're working in. With that, I'm going to pass it over to Emily, who's going to dive into some additional information and critical deadlines.
Thank you, Mitch. So, to cover the critical deadlines here in Q1 for 2026, these are just going to be a high-level view as we are going to dive in more on some of these here coming up in the next slides. But first to hit on, and hopefully is already enacted as we are past January 1st, but Missouri minimum wage went up, as Mitch had mentioned. So you want to make sure you're reviewing pay rates, any compensation plans, or any sort of wage compression risks. The Secure 2.0 Act, which stands for Setting Every Community Up for Retirement Enhancement. This has taken place as well since January 1st, and essentially the Roth catch-up contributions for employees who are earning 150,000 in the prior year, meaning 2025 FICA wages. There are some compliance updates there that we will touch on in the next slide, I believe. And then we have the Mental Health Parity and Addiction Equity Act. And so some new requirements also take place. And essentially, it's now actively being audited, and it's not something that is optional. And then come January 19th, which is obviously coming up here soon, you'll want to make sure we have the revised OSHA HAZCOM standards. So essentially, labels and the safety data sheets are required to be updated for those specific substances for chemical manufacturers and downstream employers who are the ones that are being impacted there. And then we have the February 1st OSHA 300A form posting deadline. And this must be posted from February 1st to April 30th. And this applies even if you have 0 recordable injuries. So this 300A log is going to be for the 2025 injury and illness summary. And then we wanted to include the Colorado AI Act taking place, majorly just to raise awareness that AI is being more impacted for employers and scrutinized when it comes to hiring, promotions, terminations, and things alike. Basically, there are some issues that could have compliance risks when it comes to confidentiality and things alike in that nature. So we just want to make sure we included that as it does go live in Colorado, but just be paying attention from our aspect here. And then we have March 2nd, which is going to be the ACA form 1095C for to get to the employees, which is going to be for the 2025 tax year. Paper filing deadline for the form 1094C and 1095 is going to be to get to the IRS. And then any electronic submission deadlines for the OSHA injury and illness data form. So that's going to be your 300A, 300, and 301. And then March 31st, to round out the quarter, some deadlines we need to focus on would be the physical inspection of a physical inspection or to apply remote verification to I-9s completed during COVID flexibility, which was a period of March 20th, now ending the end of this quarter of March 2026, which we will be hitting on here shortly. And then the electronic ACA filing deadline to the IRS is also March 31st. A good pro tip is to have a compliance calendar of sorts with multiple eyes on it. So HR, payroll teams, finance teams, and leadership even. We find that the majority of compliance risks missing these deadlines is when employees are on vacation or there's staffing transitions. So having that calendar to multiple employees with multiple eyes on it is definitely going to be helpful to avoid missing these deadlines. And Kyle, you can go to the next slide. All right, so we're going to dive into the Setting Every Community Up for Retirement Enhancement Act, as this is the 2.0 version. So there are updates when it comes to the employees earning over 150,000 in 2025 FICA wages may no longer make pre-tax catch-up contributions. So previously it was pre-tax. Now we need to be making sure that this is on an after-tax basis for all the catch-up contributions. And this is going to apply to the 401k, 403b, and governmental 457b plans. And so essentially this threshold is not indexed for inflation and must be assessed annually. So you may be asking, why does this matter? Overall, this is not optional. So HR and payroll must be acting now, and failure to comply can invalidate catch-up contributions and create plan qualification risks. So essentially, plans that allow catch-ups but maybe do not offer Roth features must either choose to add Roth contributions or eliminate catch-up contributions entirely. And so this decision affects participants' saving behavior, their retention, and plan competitiveness, as the Secure Act is designed to help older workers accelerate savings as retirement approaches, and then they can make up for years with lower or missed contributions. So overall, payroll needs to identify those impacted employees. So again, that threshold of 150,000 for the previous year's FICA wages, and then automatically redirect only catch-up contributions to Roth, and then maintain the correct pre-tax versus Roth treatment for those regular deferrals. And so this is something that we are all handling manually. So this can obviously create some error and audit risk throughout, as we're just all humans and we make mistakes. So ensuring multiple eyes are on this as well will be extremely helpful. When it comes to the actual contribution limits per plan, this is again probably going to be the more complex part of the updated act here. But when it comes to the 401k, 403b, and 457b, the employee deferral is going to be that 24,500, and then the catch-up plan is applied to employees that are 50 years old and older, and that catch-up is going to be the 8,000. And then there is the super catch-up option, and that applies to the 60 to 63-year-olds of 11,250. And then of course we have the simple plan IRA and that 401k. And then we have the actual IRA. The one I want to note here is the one I want to note is for the IRA when it comes to that super catch up, it does not actually apply. But overall, let's say the employee who turns 50 at any point in 2026 may contribute extra catch-up amounts. So if they earn more than that 150,000 in FICA wages in 2025, those extra contributions must go to a Roth account. And then essentially a good plan of action, of course, is going to be identifying those employees affected, again, meaning that threshold, and then update your payroll system. So configure automatic Roth designation. So again, you're going to want to validate testing and reporting accuracy to avoid any risks. And then amending the plan documents. So essentially the legal paperwork, if you will, you are allowed to have the plans to be amended and signed by December 31st, but the rules themselves are already in effect. So you as an employer need to make sure you're running payroll correctly, apply eligibility rules correctly, and administer those contributions correctly. And then overall, I mean, you want to plan correctly before the paperwork catches up. And we all know paperwork is not fun. As far as the long-term part-time employee eligibility, there is a lot of risk here when employers are not necessarily tracking part-time hours. So the plan now provides participation to employees at least 500 hours per year. And what has changed here is it's now 2 consecutive years where it was 3 prior to this year. So basically what this is going to trigger is those employees that were part of the 3-year portion are now qualifying in 2026. So we want to make sure you're tracking the hours accordingly for 500 plus per year. And why does this one matter? Many employees, again, aren't tracking necessarily the required precision of the 500 hours, thinking that part-time employees won't qualify, but they most definitely do. And when missed enrollment happens, this can trigger the plan disqualification. There's corrective contributions that are going to happen. And then it can also lead to non-discrimination testing failures. Kyle, you can go to the next slide. Perfect. When it comes to this next topic, we're covering the ACA affordability. So essentially, this is applicable large employers, so 50 plus full-time employee equivalent, face the affordability threshold at its highest peak, which is 9.96%, which is up from 9.2% last year. So this sounds like a pretty scary number overall, and you think it's going to be a major impact initially, but it actually helps and benefits employers. Basically, the plans will become more affordable, so you can have it reduces risk when it comes to the affordability plans, but with that, the penalties are increased with this. So this matters because as these plans become more affordable, mistakes are also more expensive. So when it comes to the safe harbors overall, and essentially safe harbors are IRS approved ways to prove affordability using information employers actually have. So in ACA terms, employers are required to offer the affordable health coverage, but employers don't know employees' household income. Again, they're going off of information that they have. So the IRS gives employers the safe harbors they are allowed to use instead. And so if you follow a safe harbor correctly, the IRS will treat your coverage as affordable, even if an employee later qualifies for a subsidy. So when it comes to the federal poverty line safe harbor, you can cap the employee's monthly premium at a very low dollar amount, of than the maximum being that $129.89. And if you stay under that amount, coverage is automatically considered affordable. So this is a lowest risk, simplest method overall. It's more of like a set it and forget it kind of option. And then the next one would be the W-2 wages safe harbor. And you base affordability on what the employee actually earned last year. And then premiums must stay under that 9.9%, 9.96% of their W-2 wages. And then this plan works best for stable and salaried employees, as this uses real income. And again, it's only what you can see. It's not basing it off of household income. And then we have the rate of pay safe harbor. This is where you base affordability on the employee's hourly rate. So the formula assumes 130 hours per month. And then this must use the lowest rate paid during the month. And this will avoid tracking fluctuation hours. So it becomes a little bit more simplified. And of course, like I said, all of these come with risks. So without a safe harbor, affordability is judged on the household income, which employers cannot verify or control. So these safe harbors reduce audit risk. They're going to create the predictability and compliance, as well as protect against unexpected penalties. So when that comes into the fun part of dollar amounts here, there are two types of penalties. There's one considered the sledgehammer, and then there's one considered the tack hammer, both which sound scary. So when it comes to the pay or the penalty amount, this applies if coverage is not offered and not affordable. So the sledgehammer is going to be that $278.33 per month, or it could be the $3,340 annually per full-time employee minus the first 30. And then this is triggered when coverage is not offered to enough employees. And then we have the tack hammer. And this one is triggered when coverage is offered but not affordable or not minimum value. And this is going to affect per employee. So that can obviously be an extremely high penalty overall. So basically some key takeaway here is going to be that affordability threshold actually helps the employers, and then the penalty exposure is still rising. So even if things are simplifying or being more beneficial for the employer, it's important that overall compliance is being met, as well as just the tracking and the math and all the things with it, as annual affordability testing remains critical. And then we tacked on here at the end of the slide, the mental health parity compliance. Essentially, the enforcement escalates in 2026. Like I said, this act is actually being audited. It's not optional now. So essentially what's changed is that the self-funded plans must now maintain documented comparative analyses and focuses on non-quantitative treatment. So we're going to be focused on prior authorization, medical necessity criteria, network standards, step therapy, exclusions, and like fail first rules. So overall, you'll see that plans must produce analyses within 10 business days of regulator request. And if it's found non-compliant, participants must be notified within 7 business days, and regulators are actively requesting documentation. So why is this a high risk compliance piece? Again, it's no longer theoretical, and agencies are issuing monetary penalties, mandatory corrective actions, and public disclosure requirements. So employers need to take action in the sense of confirming whether your plan is fully insured or self-funded. And then you'll want to work immediately with your carrier or benefits counsel, and then ensure comparative analysis exists and they're current and defensible. You can go to the next slide. All right, so the next one we want to hit on is immigration enforcement. So essentially, we are seeing an uptick in the auditing happening for ICE, and it's not just border patrol anymore, if you will. So there are, or within the beginning of 2025, we've seen a 30% increase, which was 5,200 notices of inspection. And so essentially that notice is notifying the company that they're about to be audited, and that notice is going to have what compliance pieces that need to be met within a very quick turnaround time period. I believe it's up to 3 days usually. And that's where ICE is going to be requesting current employees, terminated employees, any supporting documentation throughout the I-9 process. And we are seeing this uptick across hospitality, agriculture, construction, healthcare, manufacturing, staffing agencies. But essentially, companies should be framing their mind of when will I be audited, not if. So you'll want to always be prepared and make sure you're in compliance. I know all your guys' eyes are probably looking at the chart for the penalties and just seeing how high that dollar amount is. And it's something as minor as the date being incorrect, and you're not following the month, day, year. And then the biggest hit that we want to touch on here is that cleanup deadline. So the remote documentation examination during COVID flexibility, and again, that was March 20th to March 31st. You must physically re-inspect these documents or apply the permanent alternative, which would be requiring to enroll in E-Verify and then have live video interaction with employees presenting original documents and retention of document copies. And this is all needs to be done by March 31st if you have not already complied. So definitely get those plans in place on how to tackle this, especially if you are a larger employer, and figuring out how many employees you might need to complete weekly versus the next couple months here, especially because you have to rely on the employee to bring the physical documents to work for you all to inspect. Another thing we want to hit on here is using current I-9 forms. That's something that we see a lot if we are doing audits for our clients. Is a lot of times, sometimes they're using the wrong form and it's expired, and that is considered a technical violation, and it can be $288 up to $2,861 per form. So that is an extremely high dollar amount, especially if it's going to be multiple forms that are expired. And then when it comes to the knowing hire, so essentially this is when you are knowingly hiring or re-verifying an employee with unauthorized documents. This is how it is going to look when you have your first offense versus second versus third. I think the biggest thing that we want to highlight here is the fact that it's either per form or per worker. It's not an overall, hey, we noticed a theme here and you're going to be penalized by this dollar amount. That dollar amount is dictated per something. And then when it comes to knowing hire or like those type of violations, that's where you are taking incorrect documents. Say you are accepting a list A document with a list C. Technically, list A is covering their work authorization and their identity, so list C does not necessarily need to be taken. So just paying attention to those kind of things. Current forms can be found on the USCIS website. And so if you are using electronic I-9 systems, you want to make sure that you get that updated, because the I-9 system most likely has the form that is expiring here in July. So make sure that you get that updated. And there is also like an employer handbook on how to appropriately fill out an I-9 form section by section. As we all hopefully know, section 1 is filled out by the employee. And this is where a lot of those technical and paperwork errors come into play, because it's a little misleading when the employee has to fill it out. So when you're looking at it and verifying their documents maybe later and the employee's not necessarily there, employers are not correcting what's wrong on the form. And a big one is if they are seeing a theme with the citizenship status. So that's where they're selecting if they are a citizen of the United States, a lawful permanent resident, so on and so forth through the 4 options there. So just knowing that the form does matter to be filled out correctly, and it is looked at. So we are kind of highlighting that the end of this quarter, of course, you have to follow the COVID flexibility deadline here. But when it comes to just internally auditing all your I-9 forms, we definitely suggest doing that annually as a best practice. So you can stay ahead of the game if you ever do become audited. Like I said, it is more of the mind frame of when will we be audited, not if. And then Missouri E-Verify requirements. So public employers and state contractors with contracts exceeding 5,000 must use E-Verify. And penalties include a minimum 14-day business license suspension for the first offense and 1 year suspension for the second. So if you hold state contracts, E-Verify enrollment is not optional. It's a condition of doing business with Missouri government entities. So if that's something that you need to flag for yourself to correct and sign up for E-Verify, there is plenty of information through the USCIS website as well, that can help with getting you logged on and setting up the account and who's verified to actually run E-Verify and who needs the training and things like that. But overall, I'm going to pass it over to Kyle. I appreciate your time.
Thanks, Emily. Next, we're moving on to the EEOC and enforcement shifts, but even though there have been shifts and some regulations were rolled back, enforcement actually has intensified and not really softened, even though it might not seem that way. So a common misconception might be that because certain rules were vacated or repealed, that enforcement has slowed down, but the data has said quite the opposite. The EEOC has actually recovered over $700 million for employees, and that was just last year alone. And it filed more than 88,000 new charges, which is one of the highest enforcement years on record. I believe 2 years ago may have been the highest, or could have been last year. But 2 years ago, they had even hired an exponential more amount of investigators specifically to weed out any potential EEOC violations. So regardless of if some things were vacated or pulled back, they are still not drawing back on their forces and they're investigating. Their strategic enforcement priorities run through 2028. So they usually release a 3-year strategic enforcement plan, and that kind of tells us exactly where the regulators are looking. Some of those key enforcement focus areas are going to be AI and algorithmic bias in terms of hiring. So that could include resume screening, automated video interviews, algorithm-based scheduling or performance scoring. And the risk is employers don't often realize that these tools are making employment decisions. And websites like Indeed are making it even more complicated at times. They change their procedures a lot. They change how they offer different tools, which might be extraordinarily helpful for employers, but could come with the added risk that there are AI tools woven within that you might not even be conscious of. And just because you have some resumes or contacts saved within that software or that database doesn't mean that's actually how you're supposed to save them down into your own internal systems for potential audits that may come along. Another focus area is going to be vulnerable worker populations. So that could include older workers, immigrant workers, or low-wage or hourly employees. The next focus area is going to be on pay equity. So that can be gender and race-based disparities, inconsistent starting pay, or compression issues after minimum wage increases, and also harassment. And not just the typical harassment that you might be thinking of, but also third-party harassment. So that could include customers and vendors. We don't always think about workplace harassment as including the vendors that come in, whether it's a restaurant and they have, their liquor distributor come in. But if they're making disparaging remarks to any of the employees, that can actually be considered workplace harassment and your company could be held liable. And also remote work digital harassment. We might think that harassment is almost impossible when you have a remote workforce, but that is absolutely not the case. The same rules apply. So that is going to be some of the key enforcement focus areas that they're going to be looking at. If you take nothing else from this slide or just this portion of this slide, remember documentation, consistency, and transparency are always going to be your best defenses. Moving on to pregnancy, pump, and religious accommodations. So the Pregnant Workers Fairness Act, or PWFA, it applies to employers with 15 or more employees, and it's broader than the ADA in some aspects. And it states that you must provide reasonable accommodations, even if the condition is temporary and even if it doesn't rise to a disability. So that's somewhat how it differs from the ADA. Some things that could apply are water bottles. Maybe you need to provide more restroom breaks if you have a pregnant worker on staff, sitting and standing flexibility opportunities, and possibly a modified lifting requirement. These accommodations are considered reasonable almost by default. And then we also have the Pump Act, and this applies to all employees regardless of the company size. And that states that you must provide reasonable break time, a private non-bathroom space. So a bathroom is not going to qualify in terms of the Pump Act. And that could be through the range of 1 year after childbirth. We still do see some violations simply because employers assumed that older exemptions might still apply. So keeping abreast of the most current updates and keeping your managers and supervisors and everyone who's in charge of making sure that these are rolled out across the organization are the people you also want to make sure these updates are getting to. And then we also have religious accommodation. The Grove versus DeJoy suit has come to significantly raise the bar for denying religious accommodations. So you can no longer deny based on more than a de minimis cost. So you must show substantial increased costs to the business. And that means coworker inconvenience alone is no longer enough. Moving on to OSHA deadlines and the coming heat illness standard. Well, we're definitely going to speak on this, but I do want to preface it with the fact that we are well-versed in all things HR, and this absolutely intertwines with that. But we also do have safety experts on our team, which if you are part of our phone or email support, you can reach out to them at any time as well. So we have an HR email and then a safety email and phone number, and we also have a DOT, even though it's not totally relevant to this slide, but they're going to know a lot more and be in the weeds, really looking at the biggest updates, and going to be able to give you the best insight into this. But we did want to highlight it because it is quite important. So it's the most significant pending rule, and that's the heat illness prevention standard. They completed their informal public hearings in mid-2025, and it's supposed to be finalized by early 2026 with a 150-day phase-in period, but it is quite possible that this continues to get pushed back. We have been following it for, I'd almost say 3 years now, and we keep waiting for it to officially come into or propose or move from the proposed rule to an official rule. And we still wait and we still keep updated, and it keeps getting pushed back. But knowing about it is the best protection, and knowing what could come is the best protection. Because the OSHA enforcement is aggressive even before the final rule is issued. The most important thing to understand about OSHA is that you don't need a final rule to get cited. They can absolutely still cite you, and that could be really because the heat illness is currently enforced under the general duty clause for OSHA, and there is a national emphasis program on heat illness enforcement, and that's going to run through at least April of this year. What is expected now, and not necessarily when it's officially goes into law, is that all employees are able to have access to water, access to shade, acclimatization plans for new or returning workers. And that just means if a new worker is not going to have the same heat experience, if you will, that someone who's been on the job for weeks or months. So they're going to need to be slowly acclimated. So not to expect that someone can handle the same amount of heat that someone who's been there for years can handle. So just making sure that it's taken in small batches and really helping their body to adjust to their job if it's in a very hot environment. Employers are also requested to monitor the heat index. So when it's 80 degrees Fahrenheit and above, that might trigger a concern. So just keeping abreast of what the actual temperature is, and changing any necessary tasks or roles or responsibilities that employees may have if it starts to go higher and higher. And probably most importantly is training supervisors to recognize these symptoms and what heat illness looks like, whether that is heat rash or whether it's complete, passing out, or if they have nausea or vomiting, or if they are dizzy. So there's a lot of different resources out there to help with that. IRONWOOD does have some because we have created a lot of different helpful tools for that, and we're more than happy to send that on. We'll actually have a heat illness standard website, which will go live pretty shortly. That IRONWOOD created and controls. So we're happy to send that out as well if this is something that is of concern of any of you guys. But bottom line is waiting for the final rule is a mistake because OSHA will ask, what did you do to prevent foreseeable harm? And what did you do to give the basic general protection of your workforce? But a couple of things that we just really wanted to highlight is the cost, which is much like Emily was showing you on the other slide. The violations are pretty substantial. So for a serious violation, that could be $16,550 per violation. For failure to abate is $16,550 per day. And willful or repeated violations, so if OSHA had come in and had found some violations on your property or on your site or in one of your facilities, it could be $165,514 per violation, and one willful violation can cost more than an entire annual safety budget. Emily spoke briefly about the HAZCOM compliance timeline. So as of January 19th, all chemical manufacturers must update substance labels or SDS labels. By July 20th, employers must update workplace labeling programs and training for substances. Oh, sorry, this one. No, by July 19th, 2027, manufacturers must update mixture labels and SDSs. And by 2028, employers must update for mixtures. AI and technology regulations, we're going to see a lot more coming down about this in particular. And we did want to include just some of the Colorado and New York local laws just to see what the evolution could kind of look like. And we wanted to include something on some of the Illinois regulations as well, because you could easily have an employee in Illinois. But the core message here and the core message that we are seeing from lawmakers is that AI regulation is location-based. It's not headquarters-based. So even if you're headquartered in Missouri, but you have employees in another state, you want to make sure you know the regulations on all states where you might have an employee based. There's no single federal AI employment law, but that doesn't mean that it's completely unregulated. So if you have applicants or employees that are in those regulated states, those laws are going to apply to you, even if you're headquartered in Missouri. Just to give a little bit of an example of what some of the new laws, especially Illinois, because that could be pertinent information for you guys if you have any employees there. Illinois AI law, or HB 3773, it applies even if you have one employee in Illinois, and it requires notice of when AI is used, prohibition on discriminatory outcomes, and explicit ban on zip code proxies. So zip codes are now being treated as red flags because they correlate too closely with protected classes. So that could be a more low income area in Illinois. And so they are now being treated as an explicit ban. The Colorado AI Act, Emily also kind of referenced, this one is particularly important for mid-size and large employers. And again, this is just something to watch because it could easily be applied within Missouri at any time. So that the requirements include 50 plus employers. There must be risk management policies in place for AI. There must be annual impact assessments. So how is AI in your hiring? How is that affecting the overall organization and the overall applicants, candidates, and new hires? And a reassessment within 90 days of any changes. That's governance level compliance, and that's not just HR admin work. And the New York City law already is active, and it requires independent bias audits and public posting of results. So even vendors must comply, which can impact availability and pricing. The main takeaway here is that you must have a good grasp on the inventory of the tools that you use. And if you can't really explain how a system is making a decision, that's going to be a problem. So for example, if you use AI-powered applicant tracking systems or resume screening tools, video interview analysis, or algorithmic scheduling software, inventory, which jurisdictions your applicants and employees are located in. The strictest applicable law governs your compliance obligations. Now we move on to non-competes. The main message here is that non-competes are live, but ones that are sloppy, if you will, they could still fail. Despite headlines, non-competes are still enforceable under Missouri law. The key things to remember is that in order for a non-compete to I don't know what the word I was looking for, to not have any holes or not be considered sloppy or be able to have a suit brought against you. They must protect legitimate business interests. 1 year is presumed reasonable. Geographic scope must be narrow, and courts may blue pencil, but don't rely on it. So they might go through and through your non-compete and find specific things that if they're not truly abided by, then you are going to want to make sure that you're following everything that's in your policy. And non-solicitation agreements are often more defensible and just as effective rather than non-compete. And the best practice that we suggest is to draft separate non-compete, non-solicitation, and confidentiality provisions rather than combining them into a single agreement. If one provision is found unenforceable, the others could still survive. So, and consider offering continued compensation during any restricted periods, and courts are more likely to enforce agreements when employees receive consideration beyond just initial employment. We have a few Missouri-specific compliance checklist items. We've talked about a lot of this. There's no need to go over all of them, but just to remember immediate or as soon as you can, because January 1st has come and gone quite quickly. We're already at the 6th, yep. To update all your payroll systems, download and post any new minimum wage posters, decide on any voluntary sick leave policy and provide written notice of any changes, verify overtime exemption classifications under reinstated threshold. Some Q1 2026 deadlines is to make sure you post that OSHA 300A form, and that goes until April 30th. Submit any OSHA record keeping requirements, furnish form 1095C by March 2nd, and file with the IRS by the 31st. Complete your I-9 cleanup. And ongoing compliance is maintaining workers' compensation insurance, filing your quarterly unemployment insurance reports, post any Missouri Human Rights Act discrimination notices, which the Missouri Human Rights Act applies at 6 employees, not 15, which is kind of a common misconception. Make sure you're following any final pay requirements, so immediate final pay upon involuntary termination, 30-day notices before there's any wage reductions, and make sure your E-Verify is mandatory and make sure that you know that E-Verify might be mandatory for certain contracts. So oftentimes that'll be government contracts, but in some contracts, E-Verify for your entire establishment is mandatory. Most multi-state employers get cited here because they assume federal threshold might apply. And just to take a look at the Missouri workers' compensation benefit rates. So temporary total disability is $1,280. Permanent partial disability is $670, and mileage, the current mileage reimbursement right now is 70 cents a mile. Some of the most common compliance mistakes to avoid these are the key things that we see when we get our phone calls and our emails, but that's going to be wage and hour. So that's assuming the overtime threshold has increased, and it didn't. Making sure you're classifying your employees as exempt based on the job title rather than the duties analysis. Failing to pay terminated employees immediately, so that's that final pay, and not providing 30 days written notice before some wage reductions. There's also benefits and retirement, safety and posting, so that's going to be those OSHA 300 logs again, and not updating your HAZCOM programs for the July 2026 deadline, and inadequate heat illness prevention in outdoor work environments. Some Missouri-specific mistakes are maintaining that paid sick leave compliance for the repealed law, which is, this one actually benefits employers if it was providing a higher, if it was providing more paid sick leave than they had initially offered. So this is actually kind of a bonus if you guys were struggling to make it, but you don't have to maintain that sick leave compliance anymore. But you will want to update any policies that you put into place when that was in effect. Assuming the federal 15 employee threshold for discrimination laws when Missouri's is 6 and under. Believing any E-Verify requirements are optional for state contracts when it's mandatory for contracts over 5,000, and for getting any of those immediate final pay requirements that might be unique to even, not just Missouri, but even could be by city. So you want to make sure that you are following all requirements based on not just the state or the federal, but also the city or county. Immigration compliance and any classification errors. Classification errors are always going to be one of the things that we are helping counsel employers through. It can be very confusing. It seems like it can change, and it can seem like it'd be based organizations depending on what the organization is, and sometimes it can be. So if you ever need help trying to do a classification analysis or audit, we're happy to help with those because it can be really confusing. This is just a basic chart of the key penalty summary for 2026. There's a lot of fines there that we don't ever want to have to be audited on or forced to pay. So mostly this is about risk prioritization and not fear. We don't want you to see this and immediately go into a panic. And not all violations carry equal risk. So if resources are limited, just focus where penalties are the highest, if that's the only thing that you guys can tackle right now. And you're more than welcome to reach out to any of us at Ironwood, and we can help give you some insight into how to avoid those violations. I would probably emphasize I-9 and knowing the hiring penalties, any OSHA willful violations, ACA penalties, and final paycheck violations. One audit failure can cascade into multiple penalties, though. And we just really want you guys to move forward with confidence. 2026 and the years prior and the years that are in the future are all manageable with good systems. So action steps can be updating your payroll systems, making sure those are all in compliance. Complete that I-9 cleanup. Audit any AI tools that you might be using, and establishing quarterly reviews. Compliance is definitely not a 1-year-long project. It is an operational discipline that we are pretty well versed in helping create or helping walk through and giving tips on. So we're always here to help you guys. But our final recommendation, and hopefully you guys found this all helpful, but our final recommendation is to complete a comprehensive HR audit before the new year, or as the first week of the new year, second week of the new year, to identify any gaps you guys might see in documentation, posting, and policy compliance. The cost of an audit is a fraction of the penalties for noncompliance, and addressing issues proactively demonstrates good faith that can reduce penalties if violations are discovered. That was a lot of information, but we're happy to answer any questions and you guys might have put in the chat. I haven't been able to track those like I normally do. Or if you have any questions following this, you can always reach out to HR@ironwoodbc.com, especially if you are signed up for our phone and email support.